Welcome to the resumed hearing in the Supreme Court of the reference from Northern Ireland of a question as to the competence of a provision in the Abortion Services Safe Access Zones Northern Ireland Bill. We're hearing submissions on behalf of the Attorney General for Northern Ireland presented by Mr. McLennan, and I'll invite him now to continue his submissions.
Thank you, my lord. I'll take guidance from the court on timings. We did have a later start. I would have been scheduled to finish at 2:30, but I might need a little longer just to complete the submissions.
Yes, that's all right. Don't worry. If we need to catch up with time, we can make arrangements to do that.
Thank you very much, my lord. I was taking the court to the Strasbourg decision in Lashmankin in Russia. This is not a Grand Chamber decision, but it's quite an important decision, one which is heavily referenced by our Supreme Court in the Ziegler decision, a recent decision on a similar territory. And I was flagging for the court at page 1000 the reference to relevant international and comparative material. And I'll deal with this briefly. There are three references I want to flag here in respect of the issue about location of protest, and it goes back to a point that's been raised about the facility for protesters to go elsewhere outside an exclusion zone to make their point. So the international materials, I want to flag three aspects of it. Paragraph 313, page 1000, is a reference to the UN Special Rapporteur on the right to freedom of peaceful assembly. And I'll highlight for you paragraph 40 at page 1001, a reference here to any restrictions imposed must be necessary and proportionate to the aim pursued. In addition, assemblies must be facilitated within sight and sound of its object and target audience, and to organise a peaceful assembly should not be coerced to follow the authorities' suggestions if these undermine the essence of their right to freedom of peaceful assembly. You'll see this concept of within sight and sound repeated through the international materials and picked up by the Strasbourg Court in its analysis. So that's the first reference. Second reference is a paragraph 315. Here it's quoting from the compilation of Venice Commission opinions on freedom of assembly. So it's a kind of a digest of analyses on freedom of assembly jurisprudence. And I'm highlighting for the court page 1003, paragraph 4.2, where it deals with restrictions on place. And again, this goes to the specific aspect of the Lashmankin judgment dealing with blanket restrictions on protests at court buildings. So 4.2, the Venice Commissioner saying, location is one of the key aspects of freedom of assembly. The privilege of the organiser to decide which location fits best for the purpose of the assembly is part of the very essence of the freedom of assembly. Picking up with the next paragraph, blanket restrictions such as a ban on assemblies in specified locations are in principle problematic, since they're not in line with the principle of proportionality, which requires that the least intrusive means of achieving the objective should always be given preference. And then it recommends, two paragraphs down, that blanket bans on assemblies in the vicinity of government institutions and courts be deleted, and the management of security risks left to the relevant law enforcement authorities, and in reference to the positive obligation to facilitate and protect peaceful assembly. The third international reference is found at page 1012. This is the OECD 2012 guidelines, or OSCE, 2012 guidelines on freedom of peaceful assembly, and deals with a range of points, but in particular, you'll see at page 1013, again, the sight and sound concept. So as a general rule, assemblies should be facilitated within sight and sound of their target audience. The paragraph 43, again, I won't read this, but there's a treatment here of proportionality and the blanket application of legal restrictions. Again, the court will find that of some assistance. Paragraph 101, again, this is all internal to the international materials. The sight and sound concept is restated, and the importance of being permitted to facilitate assembly within sight and sound is emphasised. And at 123, on the same, sorry, I think that's the last reference I have from that. So those three international instruments are actually then drawn upon by the Strasbourg Court at a later point in the judgment in the analysis of the proportionality balance. That's why I highlight them for the court. But it goes back again to the contention that Article 11 can be satisfied by allowing protest away from the locus at a point out of sight and out of sound of those to whom who are the potential target of the influencing, or in this case, or protest. The court rehearses the general principles set out by the Grand Chamber in Quadrivicius. So that's from paragraph 412 onwards. So that's page 1046. You have a repetition here of the Quadrivicius general principles. I don't intend to go through that again. What I say this judgment adds to the overall analysis of the jurisprudence is a material found from paragraph 430 onwards. That's page 1055. First point to note, I suppose, it's just at paragraph 430. The Strasbourg court actually found in that case that there was a legality failing. So it doesn't just fail on proportionality, it fails on legality, on the quality of law, because of the way in which the Public Events Act was being applied with lack of foreseeability. Court goes on, though, to engage in the proportionality analysis, in particular with respect to, you'll see at paragraph 431, case 19700. That's the one that I flagged for you. That's the case about the prohibition on court buildings. You'll see at 433, the Strasbourg court refers to the international materials that I just highlighted for you. And in particular, the footnote at 161, 162 takes you back to those passages that I've just identified. And you'll see, again, the court is referring to the fact that those bodies all recommend that blanket bans be avoided. They tend to be over-inclusive and disproportionate because no consideration can be given to the specific circumstances of each case. Sorry, I see my Lord Jones raises his hand. Lord Jones.
Mr. McLean, and I'm sorry to interrupt. I don't know if I'm the only one affected, but I'm losing the signal. I'm not able to hear you. You're coming through intermittently.
I don't know if that's a problem of general application.
No, I've not.
And I've lost sight. I've lost sight of all the other members of the court.
Sounds like a problem at your end. I can't hear Lord Reid.
I beg your pardon. I muted myself. I think the problem specifically affecting you, Lloyd Jones, and our engineer will have to contact you to try to sort the problem. So we'll wait a few minutes to see.
Thank you. Sorry about this.
Can I check, Lloyd Jones, have you been contacted by an engineer? It seems not. I wonder if our usher, Derek. Oh, here we are. Yes. Well, our engineer has been asked to look into Lloyd Jones's computer settings. Lord Lloyd Jones's system is being checked at the moment, so we'll just be patient.
Right. I don't know if you can hear me now.
Yes, we can.
Good. My problem was hearing Mr. McGleenan.
Yes.
Um,
He had taken.
I don't have an image on the screen of Mr. McGleenan.
Well, the rest of us do.
Right. Mr. McGleenan, I can now see you. Could you say something, please?
Yes, Lord, it should pick me up if you hear.
Yes, I'm certainly picking you up now. That's good. Thank you so much.
I think we're ready to resume. Thank you.
Thank you. It's for my Lord Lloyd
Perhaps to
Jones.
explain what Lord Lloyd Jones may have missed. You had been taking us through the judgment in the Russian case, and you'd taken us to paragraphs, particularly 430 and 433.
Yes.
We'd reached 430, and I can mark that. I can read 433.
Yeah.
Thank you.
Was particularly the second sentence's reference to the international materials that we looked at earlier.
Yes. And the purpose of looking at these paragraphs was these are additional to the jurisprudence in the earlier Grand Chamber case, and there's a particular focus on the site-specific prohibitions. And I was about to take you to 434, and again, the statement of principle here about a general ban on demonstrations in the second sentence can only be justified where there's a real danger of their resulting in disorder which cannot be prevented by taking other less stringent measures. And the court refers to the need for the authority to take into account the effect of a ban on demonstrations which do not by themselves constitute a danger to public order. But, only if the disadvantage of such demonstration being caught by the ban is clearly outweighed by the security considerations justifying the issue of the ban, and if there's no possibility of avoiding such undesirable side effects by a narrow subscription but scope in terms of territorial application and duration, can the ban be regarded as necessary within the meaning of Article 11.2 of the Convention? And that's a useful passage to measure the Section 5.2, Clause 5.2a provision against. You'll see then at 4.3.
When they say that, that's in a context of a case where there's no question of being competing convention rights to be protected.
Yes, I anticipate that point. I think that's a point raised by some of the interveners. The answer to that in this context is there will be cases here where there's a competing Article 8 right, the service users case, Clause 3.3a. There will, on our case, also be 3b and 3c cases of accompanying persons and general workers and those who are providing services caught by the same provisions where no Article 8 rights engaged. So that's the difference, I think, in this context. Lord Lloyd Jones has raised his hand again, sorry.
I'm sorry, you're breaking up intermittently again, Mr. McGlean. I'm very sorry about this.
Okay. I'm not sure what the problem is. We're actually in Supreme Court, so our signal is coming from the court. The technicians will be able to tell if we're the source of the difficulty, I hope.
I don't think you can be, because I'm not in the court and I can hear you perfectly well.
Yeah.
I think the problem must be at Lloyd Jones's end, which is reception,
I mean,
perhaps.
Lord Reed is breaking up as well.
Yeah.
Lord Reed is breaking up as well.
Well, it looks as though the work the engineer did hasn't sorted the problem. Could our broadcast engineers get back in contact with him to help Lord Lloyd Jones further? And I suggest the rest of us simply switch off our sight and sound and effectively have a short adjournment, but ready to resume as soon as the problem is sorted. And Lord Lloyd Jones, if you can Well, I'm afraid we're being plagued with technical problems today, but we're, I think, ready now to resume. Mr. McLean.
Thank you, my lord. I'm presenting on the Lash Mankin case and trying to make a bit of headway on that point. I think I was answering a question from you about the competing rights, and I think the line we take is one of the peculiarities of this particular statutory provision is that it actually captures circumstances involving those who do not actually have Article 8 rights in play, and that's sounds on the overall proportionality of point. So for those reasons, we say the Lash Mankin doctrine as set out here is still applicable to this case.
Well, why do you say that? I mean, for example, if a woman who's wanting treatment goes with her friend, both women are going to be the targets of the sort of behaviour that we read about in the parliamentary proceedings. Why shouldn't?
I hope it's not a problem at my end, but I didn't. You meant to mute partway through that observation, I think.
Yeah, I had.
Oh, I'm so sorry. I was asking really why, if say a woman goes with her friend to a clinic of this kind, and the two women run the gauntlet of the sort of behaviour that we read about in the parliamentary proceedings. Why do you say it's only the pregnant woman's Article 8 rights that are engaged?
I think there's a sliding scale here between the service user, the pregnant woman, or the person seeking counselling, the accompanying persons, who can be a range of people, and the staff and service providers. So there are probably 4 steps in the chain. What we can say with, and we don't dispute, is Article 8 rights are certainly engaged with the service user. There will be accompanying persons whose Article 8 rights are not in play because they're not seeking the service in order to vindicate any personal autonomy. They're not.
But if they're being, for example, spat at, or having abuse shouted at them, why are their convention rights not engaged?
That's the other provision, my lord. The answer to that is that's a 5.2 B and C case. We're not complaining about 5.2 B and C. We're talking about the indirect influencing case. So it's a different order of interference. So we're focusing on the lower end of the threshold, and we're saying in that context, the Article 8 rights of the accompanying person are not engaged by being the subject of indirect influence. So if we focus sharply on the offence, I'm not taking issue at all, nor is the Attorney General for Northern Ireland, with the types of behaviours my lord's describing. Those are objectionable, and those are captured by the statutory provision. What we're taking issue with is an entirely different scenario, which is someone behaving passively, perhaps standing, holding a poster, saying something like "think again" or "choose differently." Something as straightforward as that could be an indirect or recklessly indirectly influencing. That's the kind of behaviour that we're concerned about here. So it's categorically different from the BC case, which involved the service users and the being subject to harassment, alarm, or distress. So if we actually disaggregate the statute and focus on the objectionable provision, I think the analysis bears up. And it also bears up, as I say, in the gradations. Look at the difference between the woman seeking the treatment, the accompanying person, the staff member who works in the clinic, and the person delivering water or food to that facility. The rights that might be there may be rights engaged there. There may be A1P1 rights engaged, but they're not Article 8 rights in the context of influencing. So if we actually tease apart the issues that are in play in Section 5.2a, I think the analysis still holds good. And I stress the Attorney General for Northern Ireland is not bringing this reference in order to facilitate the types of objectionable behaviour that my lord has described, because the statute catches that, and that's by no means the problem in this case. But Back, if I may, to Lash Mankin.
Can I just ask a question, please?
Yes.
So if we just confine ourselves to the service users, as you've described them, would you accept that in relation to those people, there is no application of the sight and sound objection that you're putting forward? Because you need to protect their rights, that's not in dispute. And therefore this line of authority becomes irrelevant to them. Do you accept that?
I think I'm wary of accepting a proposition as broad as that, because I think where it gets you to is you still need to strike a balance with the service user, but the weight that's attributed to the service user's rights is going to be much more compelling than in the other cases. So we don't set aside the balance in those circumstances and say it's a trump card, an absolute trump card, that Article 8 is engaged in those circumstances. But clearly the weight attributed to that will be very different in those cases. So
yeah, but so you're saying the sight and sound argument, that is the right to protest in a particular location, must give way in certain circumstances?
In certain circumstances, yes, there will be scenarios, but again...
So we're then arguing really about whether these circumstances are within that or not. Otherwise, it would seem to me that to follow your argument through fully, you'd end up with no safe zones for anybody at all, which can't be right.
Certainly that's not what we're arguing for. That's not the case that we're advancing. The sight and sound requirement will be modulated or tempered by the behaviour that's being addressed. So, as I say, going back to 5.2a, the behaviours that are being addressed here are not those that cause alarm, distress or harassment. They are much more passive in nature and can be engaged at a very low level.
Can I just ask a follow-up question to Lord Reid's question? When you say the rights, there's no Article 8 rights engaged in relation to the people working at the abortion services or those accompanying, at least in certain circumstances, those accompanying, why isn't the argument that in order to properly protect the Article 8 rights of the service users, you need to also protect people who work at the abortion services and or wish to accompany, or where the service users wishes these people to be accompanying them? Why doesn't it flow on from the Article 8 of the service users that those other people be protected as well?
Well, I'll put the point a different way. In one sense, the service users can only avail of the service if there are workers prepared to go there and conduct the exercise. It's a much less objectionable protest to direct influencing towards people who are at work than it is to vulnerable people who are going to seek a service. And if the right to protest isn't eroded of all meaning, then it must suggest permit some means of expressing a view to those who work there. And interestingly, the Court of Appeal in Bulgaria were of the view that the Article 8 rights could be balanced in circumstances where protest was still facilitated, because what was key in that case, and the key differentiating factor for this case, is that there was a designated zone for protest. So protesters were able to make their point within sight and sound, but at a distance, and the balance was struck by that method. What's problematic with the statute provision we're looking at here is there's no facility at all for protest, even in a designated area proximate to the site. So the Court of Appeals already looked at this point, and as I say, we in essence stand behind that analysis, because the court said we can readily see Article 8's in play with the service users, but not at all clear in respect of the others. But still was of the view that Article 8 could be protected with a protest allowed in certain limited ways. So that appeared to us to be a means of striking the right balance. That is not available in this context, in the Northern Ireland context.
Can I ask a question about the other side of the equation? The sight and sound aspect of Lashmankin seems to be primarily directed at protests towards lawmakers. But do you say that Articles 10 and 11 protect a right to persuade someone who has absolutely no power over what abortion law should be, but who is a private person availing themselves of that service? It doesn't seem to be similar to the kind of protest against government bodies, people who influence what the law is. But how far do Articles 10 and 11 go towards protecting my right to persuade somebody, another person, not to take advantage of a law which they have no power to change? Is it not more to do with about changing laws or changing political manifestations?
I mean, I think the position in terms of the debate about the legality of abortion in Northern Ireland is settled. I mean, we've had primary legislation that's no longer in dispute. The service will be available, subject to certain political dimensions. That's not in dispute. The parallel that's being drawn with and these aren't perfect parallels, obviously. The Russian scenario is not protesting at lawmakers, but it is seeking to hold gay rights, pride type events in the precincts of courts, not the lawmakers, but courts who make decisions. And again, it doesn't seem to be a protest directed at influencing legislation, but simply influencing the state infrastructure. Now, that might be misguided or misdirected or whatever, but what Article 11 seems to protect is the right to engage in non-violent protest in a manner that's in sight and sound of an audience that would in some way be influenced by the action. And again, we're not, on behalf of the attorney, we're not supporting a particular point of view in respect of this, or
influence to do what? What are they? It's not influencing to do anything in the political sphere.
No, I think they were attempting to influence them not to avail of the service, to make a different choice.
And that, you say, is protected by Article 10 and Article 11 rights?
Well, it's not clear why that's objectionable per se. It's not a reprehensible act, which is the kind of concept the Strasbourg court is engaging with. It's not violent. People might disagree with it, but there'll be many who don't. So we're in that kind of territory, and it's not necessarily an attempt to change the law, because the law is what it is. It's a protest limited in its nature, and I think our submission here is it's within the envelope, a similar envelope to that which the Strasbourg court has found worthy of protection in a range of cases. And the Strasbourg court has found much more reprehensible conduct to be within the envelope of protection. I mean, the case of Faber, for example, we cited, is a case involving the flying of objectionable flags in respect of fascism at a Holocaust memorial site. I mean, there are the types of conduct that the court has said, no matter how objectionable we see and find it to be, it still falls within the area of protection. My Lady Chief Justice, I think mute. Still mute.
Yes, thanks. The decision you were looking at, paragraph 434, deals firstly with measures to militate against public disorder. Okay?
Yes.
Then I think where you are is looking at the second paragraph, demonstrations which do not by themselves constitute a danger to public order. Is that where you are?
Yes, exactly.
And if you read in that case, security considerations I think you can read in there Article 8, protection of, certainly on your case, service users, arguably others. I know, but you're clear about service users.
Yes.
Yeah. So
Yes.
you can have a ban. It says only if the disadvantage of such demonstrations being caught by the ban is clearly outweighed by the security considerations. Read in Article 8 considerations, which are explained in the Health Committee's report, I think, the effects on the service users, which justify the issue of the ban. I'm not sure there's much controversial about that so far. No.
No.
Then, are you really at the next part of this paragraph about necessity because of what's described here as undesirable side effects of the ban by a narrow circumscription of its scope in terms of territorial application and duration? Is that what your argument comes down to?
I'm not confining it to that, but that's certainly important because, again, looking at the offence provision, 5A is the objectionable section. B and C still captures what most people would consider to be the objectionable behaviours. Lady Rose has identified those. They would be caught by that part of the statute. We're not raising any issue about that. So, looking at a narrow circumscription of scope, the narrow circumscription of scope is achieved by simply using the 5B and C provision. There is no territorial or there's no well, the territorial scope. You've heard my points about that is potentially very extensive, and there's no temporal limitation. And one of the features of this decision, if you just turn over paragraph 437, one of the reasons why the Strasbourg court found that the proportionality balance was not correctly struck in this case, the Russian case, was that the restriction was not limited in time. Yeah. Applied to the entire territory. So it's the temporal scope, the geographical scope, and the fact that there is a perfectly effective tailored provision in 5.2b and c, which does the job, which I think is those are the key features of the case as far as we're concerned. And the Strasbourg court that found that in light of those sorts of problems, it hadn't been shown that the ban was proportionate in the circumstances. And at 440, you'll see again the court saying the ban should be tailored narrowly to achieve the particular interest. And we say it's not narrow actually, but there is a tailored provision in B and a tailored provision in C, which meets that need. And that's what we take out of the Lash Mankin. And again, I'll just finish on the point 441 of the same section. The Strasbourg court saying it's the absolute nature of the ban, wide discretion in the vicinity, and so forth that makes a difference. So it's a collection of those components together that causes the problem in this case.
But just on that, the necessity of the ban described there relates to the nature of the security considerations. So there has to be a relationship. And here, as we've heard, there are very stark effects raised in relation to the Article 8 considerations of the service users, are there not?
Yes, but we say there are problems elsewhere in respect of that.
Yeah, thank you.
I don't know, but perhaps we need to bear in mind in relation to 2A, the anxiety of the Assembly, which comes over in the debate to avoid leaving loopholes because of the difficulties that had arisen in the enforcement of existing laws, the police not being either able or willing to enforce existing laws in relation to harassment and the like. And although such laws existed, and they effectively duplicate, well, certainly duplicate C, and B for that matter, I dare say there would be a criminal offence that might well cover that. Do we not need to bear in mind that if the context is one where there is a real problem of the practicality of enforcement, unless you draw the offence widely, then that in itself is a reason supporting the justifiability of a widely drawn offence.
Yes, I mean there's a different answer to that, which is you can draw the offence widely, but you can temper that with a reasonable excuse defence. And what we have here is a very widely drawn offence.
Yes, but of course, the Parliament didn't want to have a reasonable excuse defence, and it eliminated discretion and so forth generally from the legislation, so as to make it, so as to get as close as they could to a clear law criminalising the sort of thing that was going on.
Yes, that's not contentious. I think the issue there is what space is left for Article 11 rights, what space is left for Article 10 rights, and I think the analysis we've put forward is there is no space left for it that meets the general requirement to have some efficacy in the right.
Yeah, well, I mean, the other view, of course, would be that they only have to go 100 meters or 100 yards, whatever it is, from the facility,
from the land on which the premises sit. Yeah. Again, we've got points to make, and we've made already. I won't labour them about the elasticity of that point, and that goes to geographical temporal application. So, I've probably said as much as I need to say about the Lash-Mankin decision. I said there was a further Grand Chamber decision of some importance in this context, and it is the Animal Defenders decision, which is at page 751 of the bundle. Animal Defenders is referenced in the Lash-Mankin decision, and one of the reasons it's referenced is because the Strasbourg Court is inviting a comparative analysis of the quality of the parliamentary and judicial scrutiny of a general measure that didn't have the type of facility we're talking about. So Animal Defenders is an authority that keeps cropping up in this context and looms large, I think, also in the justice intervention in this case. But the principle that's being stated in Animal Defenders is in respect of a ban on political advertising, which was a general prohibition introduced without exception in the United Kingdom by the Communications Act 2003, although it actually replicated legislation that was in place from 1954. Light of time constraints, I'm not going to take the court through this line by line, but from page 763, from paragraph 35 of the judgment, there's a very detailed treatment of the background to the Act, the 2003 Act. And what you see here is, again, antecedents in earlier legislation, the 1954 Act. You see the Neil Committee on Standards in Public Life reporting on public advertising. You see a white paper being produced. You see extensive consultation on that white paper and a draft bill in paragraphs 41, 42. You see the involvement of the Joint Committee on Human Rights, paragraph 43, which raised issues and concerns. You'll see the bill being introduced into Parliament, paragraph 48. The department sponsoring the bill produced a memorandum engaging with the Joint Committee on Human Rights analysis on convention compatibility. That's referenced at paragraph 50 and 51. Then, unusually, paragraph 52, and the Strasbourg Court lays emphasis on all of this, the department produced an explanatory note which exposed, it looks like, Attorney General's advice or senior counsel's advice on the convention compatibility issues in the legislation. And all of that was put before Parliament in the law-making process. Now, there's a point I think I can make by reference to submissions made earlier today. That's a world away from the parliamentary scrutiny and consideration that applied to the Privates Members Bill that became the Act that we are considering now. The quality of the legislative scrutiny is of a different order of magnitude. Similarly, in the Animal Defenders case, the Strasbourg Court was impressed by the fact that our appellate court, including the House of Lords, had also opined on the Strasbourg principles that were applicable there. So there was a judicial element of scrutiny that went into the lawmaking process. And all of that informed the court's decision on the proportionality of the measure. But the passages that are most frequently cited in Animal Defenders are found at page 787. And that is at paragraph 106. So, and the statement of principle there is that it's recalled the state can, consistently with the convention, adopt general measures which apply to predefined situations, regardless of the individual facts of each case, even if this might result in hard cases. So something like 5.2a can be put forward if certain conditions are met, even though it gives rise to individual hard cases. But there's a recognition that there's a potential proportionality problem arising. You'll note also paragraph 107, a reference to the court having examined the necessity for those sorts of general measures in a range of contexts. And you'll just, in passing, and this goes to a justice point, that Animal Defenders says nothing to the criminal paradigm. You'll note it at the penultimate line of paragraph 107, the reference to assisted suicide, and the footnotes paragraph footnote 50 takes you to Pretty in the United Kingdom. Pretty in the United Kingdom is a general measure in the criminal justice paradigm in the United Kingdom, because that's assisted suicide, which again had a general prohibition measure without any scope for mitigation in a hard case. So Animal Defenders, Strasbourg Court, the Grand Chamber, was actually looking at case law of its own court that dealt with criminal jurisdiction issues in the United Kingdom. Paragraph 108, what they say is what emerges from that case law, including Pretty United Kingdom. In order to determine the proportionality of a general measure, the court must primarily assess the legislative choices underlying it, the quality of the parliamentary and judicial review, the necessity of the measures of particular importance in this respect, including the operation of the relevant margin of appreciation. The proportionality discussion then is at 113 following, that's page 789. Paragraph 114 looks again in shorter form at the phases of scrutiny, and in the final sentence on that paragraph says the prohibition was therefore the culmination of an exceptional examination by parliamentary bodies of the cultural, political and legal aspects of the prohibition as part of the broader regulatory system governing broadcast public interest. Paragraph 116, the court attaches considerable weight to these exacting and pertinent reviews by parliamentary and judicial bodies, and notes then that the prohibition was specifically circumscribed to address the precise risk of distortion the state sought to avoid with the minimum impairment of the right of expression. So one of the things the court can do is test clause 5.2a against the barometer of Animal Defenders. Look to the quality of parliamentary and judicial scrutiny. We say bears no comparison. It's not pertinent and exacting in the same way at all, but nor is it tailored or circumscribed to address the precise risk of distortion, in that case, the state sought to avoid with a minimum impairment. It has none of that. It is, if you're looking for the tailored provision, it's not in 5.2a, it's in 5.2b or c. And those provisions are, we say, aligned to the Animal Defenders line of reasoning. So again, this is not an Article 11 case, it's an Article 10 case, but it is a helpful tool, we say, to measure the difficulty that arises in the effect of the clause in question. Now, the Human Rights Commission rely on the Animal Defenders decision, and they say, actually, the Northern Ireland Assembly struck the right balance, struck the proportionality balance in the provision. That's their case. Justice disagree. They say, no, that's not what happened. But if there is a problem with the proportionality balance, it's mopped up later on by using Section 83, 2 of the Northern Ireland Act, Section 3 of the Human Rights Act, and Section 6. So we have two august bodies dealing with human rights jurisprudence, taking different views about the application of the Animal Defenders test to this case. In itself, we say that illuminates the difficulty that arises from a provision of this nature. But what we say is that Animal Defenders can be used in this context, even though itself it was not a criminal case, because it's informed by the judgment in Pretty. I should say, and I should flag the decision in the case of Parentcheck, which is another Grand Chamber case given on the same date as Kudravicius. I alluded to this earlier on. it's found at supplementary bundle 1137. So this is volume 7. Oh dear, sorry. And I flag parent check because it's relied upon by Justice as part of their critique of the decision of the Divisional Court in Kukurian, which I'm going to come to in a moment. So parent check supplementary 1137. Yeah. This is an Article 10 case, and as I've indicated, decided the same day as Kudrova case, or dated in the same date. The issue here is about genocide denial. The individual in this case was involving himself in protests and pickets denying the Armenian genocide, which was something that was prohibited under Swiss law. It's just for a note, you don't need to go to it, but I think it's paragraph 35 of the judgment sets out the Swiss law that Article 261 of the Swiss Criminal Code has a specific prohibition. Sorry, it's paragraph 32 of the judgment, page 1166. It criminalizes someone who seeks to justify or trivialize genocide. That was the issue in the case. But the legal point that's emerging from this arises at paragraph 274 and 275. And here you'll see the Grand Chamber is dealing with the balancing of rights between freedom of expression and Article 8. And it's referring to this provision of the Criminal Code, which criminalizes genocide denial. Paragraph 275 is the pertinent provision. So refers to what the Swiss government were doing and refers to the fact that there were two concepts to be balanced here. It said that halfway down that paragraph, the concerns demonstrated that in applying the provision in individual cases, the Swiss courts needed to carefully to weigh the countervailing interests. Indeed, an interference with the right to freedom of expression that takes the form of a criminal eviction inevitably requires detailed judicial assessment of the specific conduct sought to be punished. In this type of case, it's normally not sufficient the interference was imposed because its subject matter fell within a particular category or was caught by a legal rule formulated in general terms. What is rather required is that it was necessary in the specific circumstances. Now, this point is relied upon by the justice interveners to undercut the decision of the Divisional Court in Kukurian to the effect that it is not for the court to conduct a proportionality assessment where it has an offence before it which doesn't have a reasonable excuse provision. The interveners point to this ruling of the Strasbourg Court to say this is suggesting it should be done by the court. Now, the important points are in the last two sentences, and you'll see an interference with the right to freedom of expression that takes the form of a criminal eviction inevitably requires detailed judicial assessment of the specific conduct sought to be punished. The word judicial appears there, so it suggests this is to be done by a court, and it's not normally sufficient that it falls within a particular category caught by a legal rule formulated in general terms, i.e. animal defenders. What's required of this necessary in the specific circumstances. This is pointing towards this being the responsibility of a court. There is a later decision of the Strasbourg Court in a Bulgarian case called Hanjivsky, which is found at page 1012 of the supplemental bundle. And this is also flagged by the justice interveners. And what you'll see here is a slightly different case, rather more trivial circumstances, mocking a politician by painting him as Father Christmas. Challenge to the conviction results in the reference to Strasbourg. But the same issue arises about how one strikes a balance and who strikes the balance in an Article 10 case, and it's dealt with here at paragraph 52, page 1025. So this is in 2021, a number of years later, the Strasbourg Court dealing with the same sort of point. And the last two sentences of paragraph 52 bear consideration. When an interference with the right to freedom of expression takes the form of a penalty, it inevitably calls for a detailed assessment of the specific conduct sought to be punished. Now, you'll note that's slightly different language than the Grand Chamber used. The Grand Chamber talked of a conviction and it inevitably calling for judicial assessment. Here's talking about a penalty, and assessment doesn't say by the court. It goes on to say it cannot normally be justified solely because the expression at issue was caught by a legal rule formulated in general terms. Now, we see that or read that as a retreat from what was said in the Perenchek case. Perenchek itself does not align with Kudrivicius, a case decided on the same date involving similarly constituted court. What seems to be being said here is that where there's a penalty, there needs to be assessment of the conduct sought to be punished. We read that as a reference not to the court, but as a reference to the legislature. So in formulating the law, consideration ought to be given to the conduct that ought to be punished, and it cannot normally be justified solely because the expression was caught by a legal rule formulated in general terms. Now, these two authorities are relied upon by justice, as I say, to engage in the challenge to the Cookerian analysis, to which I'm just about to turn. So I'm flagging these points. The point will become clearer as we look at the domestic authorities, which is the final topic to which I want to turn. The issue that's raised here is really not an issue on the Attorney General's reference. It's an issue that emerges out of the interventions in response to the reference. The decision in Cookerian, we understand, was a subject of an application for permission to appeal to the Supreme Court. We don't know why, but that appeal hasn't proceeded. But clearly, the tenor of some of the submissions advanced by the interveners is directed to that decision rather than the Attorney General's reference. But it is important that we analyse, and the court analyses this issue. And can I invite the court to look at what I'm about to address in terms of two competing lines of authority? There's a line of authority from the English Divisional Court, which begins with a case of DPP and James, leads to a case of Bauer, another case of Abdul, and results finally in the decision in Cookerian in 2021, which is on point for this litigation. There's another line.
Ms. McKinnon, can I just ask how long you're going to deal with this? I mean, we're certainly very interested in this, but the reason I'm asking is it's now 3:10, and you lost half an hour this morning, and you lost about 20 minutes with Lord Lloyd Jones this afternoon. But there is a limit to how long we can allow you. How long do you think you're going to take on this?
Could my Lord allow me 10 minutes?
Oh yes. Well, that's no difficulty at all. Very well.
Yes. I'll be brisk with it. The decision of James and DPP is found at supplementary bundle, page 362. It's authorities 5. This is a challenge to a Public Order Act conviction, and there are a series of cases involving convictions under the Public Order Act. The Public Order Act has two types of offences: offences which include a reasonable excuse defence and offences which don't. And the issue that arises, and it's relevant to Ziegler and the general treatment of these issues, is whether or not there is a task for the court to perform in a proportionality analysis in both types of cases, i.e. those that have a reasonable excuse defence and those that don't. Ziegler in the Supreme Court was a case dealing with a reasonable excuse defence offence, and the Supreme Court in Ziegler said it's for the court to conduct a proportionality analysis in assessing that offence. what is being developed in argument in the reference here by the interveners is the contention that that Ziegler type analysis extends to the other category of case. In other words, the no reasonable excuse defence case. And that's the 5.2a. That's what we're dealing with. So the argument is the Ziegler analysis that the court must conduct a proportionality exercise itself in trying the criminal offence applies to this type of case. And why that matters is because it is being said that you don't address these points through a reference, as we are doing. What you do is you allow the courts to deal with it after the fact. That's the point. In a nutshell, what we're saying is that Ziegler very deliberately confined that line of argument to the types of offence that carry a reasonable excuse defence. It did not extend that line of argument, that analysis, to the no reasonable excuse cases, like our case. And we rely on the decision of the Divisional Court in Kukurian, recent decision in 2021, which supports that proposition and says Ziegler doesn't speak to this type of case. The reason why I take the court to James and DPP, that's page 357 of the bundle, is because that is the authority which traces this distinction. And you'll see the court deals with from paragraph 15 onwards with the line of cases that are relevant to this analysis. And those cases are a case of De Haal and later a case of Bauer. And what the Court of Appeal found, the Divisional Court found, was that the De Haal case, which said a court is required to conduct a proportionality analysis of whether a prosecution is necessary, was wrongly decided. So De Haal was wrong. And they say Lord Justice Moses accepted that De Haal was wrong himself in a case called Bauer. And that's quoted at paragraph 19 of the judgment. And you'll see that in the indented quotation by letter D. There was then a separate decision in a case called Abdul, which also suggested that the court should conduct a proportionality analysis in a case where there was no reasonable excuse defence. That too was the subject of a decision by Lord Justice Davis. Later in this same judgment, at paragraph 369 or page 369, he too disavows the analysis, and you'll see that in paragraph 52 and 53 and 54, where he notes that Lord Justice Moses recanted from taking this approach. And in paragraph 55, he says, it follows that I myself recant from what was in effect an unduly deferential and insufficiently critical endorsement in his own case of Abdul. Stepping back into the judgment in James and DPP, you will see paragraph 32, the issue that's in play in the background in this case is engaged. So it was argued there, you'll see in paragraph 32, that there was a need to consider the interaction between the offence alleged and the rights of the accused under Articles 10 and 11. How do those rights become part of the consideration of the trial? And the court saying the fact that proportionality decision to prosecute cannot be raised, otherwise an abuse process, does not mean that Article 10 and 11 cannot play their proper role. And then it distinguishes between two types of offences, importantly, paragraph 34 and 35. For some POA offences, the position has been clear for some time, refers to Norwood and Hammond. These rights and the qualifications and the proportionality form part of the statutory defence. So if you have a reasonable excuse defence, a court will engage in a proportionality analysis in dealing with that criminal prosecution. There are other criminal justice and public order offences in paragraph 35, of which Bauer is an example, whereas the court held, once the specific ingredients of the offence have been proved, the conduct of the accused gone beyond what could be regarded as reasonable conduct in the exercise of convention rights, the necessary balance for proportionality is struck by the terms of the offence creating provision without more ado. We are in the second category. We're in the paragraph 35 category, where there isn't a role for the court to engage in a proportionality analysis. It's meant to be in the statutory provision. If it's not in the statutory provision, that's a defect and it's not competent. That's our case. But that's where it's meant to be if it's not in the reasonable excuse. Now, that then was addressed and considered by the Lord Chief Justice and a panel in the Procurian case. That's in tab 3. Sorry, this is the first bundle of authorities, page 442. So Lord Burnett's giving the judgment of the court, page 443. The central issue is whether the decision of the Supreme Court in Ziegler requires a criminal court to determine in all cases arising out of non-violent process whether the conviction is proportionate for the purpose of Article 10 and 11. And just to say this is wrongly decided. So that's where this is coming from. We say this is correct, doctrinally correct. Again, in the interest of time, I won't labour the point, but it's a judgment that picks up this issue at paragraph, if we pick it up at 49, page 453. The proposition the respondent has urged this court to accept is an attempt to establish new principles of convention law which go beyond the clear and constant jurisprudence of the Strasbourg Court, refers to Ulla and to my Lord Reid's judgment in AB 2021, paragraph 57, which you'll be familiar with. And it's argued that in paragraph 51 and 52, that it's necessary for the prosecution to prove in these types of cases that a conviction be proportionate after carrying out a fact-sensitive analysis, or in the alternative, that you read down the statutory provision or read into the statutory provision a requirement for proportionality assessment. And what follows then is the Lord Chief Justice going back to James and DPP, going back to Bauer, and indicating that the approach was corrected there. And ultimately, if you move to paragraph 67 of the judgment, you will see for these reasons, the court saying it's impossible to read the judgment of Ziegler as deciding there's a general principle in our criminal law that a person is being tried for an offence which does engage Article 10, the prosecution, in addition to satisfying the ingredients of the offence, must also prove a conviction be a proportionate interference with those rights. So Ziegler deals with a case with a reasonable excuse. The contention is the same approach should be read across, and the divisional court said that's wrong. And it said it was wrong in reliance on earlier weighty divisional court authority in Bauer and earlier authority in James and DPP. And what's being suggested by the interveners is this is wrongly decided, and what we really should do is expand Ziegler into this category. And doctrinally, the divisional court has rejected that. And you'll see the reasoning for it is set out at paragraph 69 and 70.
Mr. McLean, can I just ask a question? What is your submission in relation to the Northern Irish case of Lee Brown?
Yeah. I appeared in that case for the prosecution, and Lady Chief Justice will recall it. That's a case where these lines of authority, which I'm opening to the court now, were not subject of any consideration or debate. We didn't examine this at all. What happened in Lee Brown was it was taken as a given, essentially, that the Ziegler analysis applied to the public order offence in question. So we didn't actually have an argument on this point. So it's not a case that actually grappled with the competing lines of authority. In fact, didn't grapple with any of the lines of authority that are sounding on this issue. So,
but on your approach today, you would have to say it was wrongly decided, would you not?
I think that's right. Yes. And I bear part of the responsibility. I didn't draw the authorities to the attention of the court, although Procurian only emerged after the Lee Brown decision. That's a decision of March 2022, so we didn't have it. And all of this was perhaps below the line of vision of counsel, and we didn't serve the court well in that regard. But on this analysis,
because I'm right in saying that there was no reasonable excuse defence on the in relation to the events in issue in that particular case, and yet a Ziegler fact-specific analysis was undertaken.
Yeah, at the point, I put it this way: the point was assumed rather than argued for either way, and the court proceeded on that basis. So I think that's where we get to on that. But what we say, what's the countervailing line of authority? The countervailing line of authority.
Yeah, can I just ask, with Ziegler, it seems that the way you've presented it so far and the way that justice presented it is that it all turns on whether there is a reasonable excuse defence or not, which seems odd when some of the statutes predate the Human Rights Act. But is the presence or absence of a reasonable excuse defence an example of a broader consideration, which is, does the statute as drafted in fact strike a proportionality balance itself, or is it to be interpreted as leaving to the magistrates or the jury to strike that balance? And one could have a sort of part-way house where one could say, all right, when striking a proportionality balance, the magistrates' court, it's not up to them to decide whether 100 metres was right or whether it was right to have these safe access zones, whether it was right to include 5.2a. What they might need to look at is look at this specific conduct, which may not have been in the contemplation of the legislature. It's still open to them to say that it would be a breach of rights. But generally, looking at this legislation, it is intended that the legislation itself strikes the balance, and that's something separate from whether it actually includes a reasonable excuse defence or not.
I think there are two ways through this. In one sense, you either have a reasonable excuse defence, maybe there are more than two, but for the sake of discussion, two. Reasonable excuse defence, or you bake the proportionality balance into the provision. So does it reduce to this, a question of whether or not the proportionality balance is properly baked into 5.2a? We say it's not. If it's not, then it's a competence problem, and the court can identify it's readily corrected by resorting to the first method, either modify it by reasonable excuse or strike the balance slightly differently through the wording or the other features of the Act. Now, interestingly, interveners say, don't worry about all of that now, don't be doing this now, let the bill stand and it'll be mopped up through the criminal process. Well, that's trouble, we say, because that's subject to the vagaries of litigation. We don't know if that's going to happen. And you're relying on summary prosecutions in the Magistrates' Court to develop jurisprudence in an issue in which expert bodies are currently disagreeing before this court. That's not easy, we say. There's a more straightforward route, that is to address the issue through competence. There's a separate problem. In order to get into that Section 3, Section 6 reading to cure the issue, or Section 83 of the Act, you have to be getting into the territory of saying, actually, there's a compatibility problem in the first place. That's how you get to the creative, interpretative rules that can give you the leverage to achieve those outcomes. So it seems to me that a first premise of some of those who are saying that's the remedy is to actually accept our case. And really, are we not arguing about different methods to really address the problem that we all recognise, that this provision is one that doesn't have proportionality properly baked in? So I think that's where it falls from our perspective. And this, the Kerkurian line of authority, we say, is sound, but and it can be applied in this context. And the attempt to get around that, I think, is one that the court should look at with some caution. So I realise I'm testing the court's patience with time, but I think some of these points I can address in reply. We say the attorney has not brought this reference lightly. I've set out the lawmaking process. I've set out the difficulties that arose in this case. We don't accept that there are high hurdles to overcome in order for a court to address this point. And we say it's entirely legitimate and indeed important for the court and important for the dialogue with devolved legislatures for the court to grapple with the competence question like the one we've raised. And we say the answer is as we've set out in our written case. Well, ultimately, I've probably gone on for too long, and I'll end my submissions there.
Thank you very much, Mr. McLennan. Well, we'll turn now to the Lord Advocate, and we'll bear in mind, Lord Advocate, that you're starting an hour late.
Thank you, my Lord. And my Lord and my Lady, in this submission, the answer to the question referred to this court by the Attorney General is yes. In my submission, there are two issues of principle raised in this case which lead to that answer. In summary, firstly, it cannot be said that in all or almost all cases, Clause 5.2a will be a disproportionate interference with the rights under Articles 9, 10 and/or 11, and thus out with legislative competence. And secondly, the duties of public authorities under Section 6 of the Human Rights Act require that safe access zones can only be sought and granted if, not least having regard to the penal provisions applicable to them, the safe access zones would be compatible with convention rights, including Articles 9 through to 11. This summarised position on the issues of principle, which indeed are applicable across the devolved settlements in the UK, will be developed in my submissions. But the underlying question is this. I recognise at the outset that the issues of principle are linked to the underlying question of proportionality of Clause 5.2a, not least because I submit that the bill can operate in a convention-compliant manner dependent upon the particular facts of any given case. And in that regard, Scotland is experiencing similar issues to those in Northern Ireland in connection with protests and vigils outside abortion clinics. These protests have intensified over the last year, with reports of patients and staff being distressed. The Scottish Government convened a summit on the 21st of June of this year and committed to the introduction of legislation, noting that a private member bill is currently being consulted on. It's currently in a draft form. Therefore, I shall also make submissions addressing the proportionality question, in particular, the balance to be struck between the interference with the Article 8 rights of protected persons and the interference with the rights under Articles 9 to 11 of others. In that regard, it is noted that the Attorney General correctly recognises that Clause 5.2a pursues a legitimate aim, namely protecting the rights of others, and captures acts which engage the Article 8 rights of service users attending protected premises. And in that regard, I'd point to the Attorney General's case at paragraph 9 of the core bundle at tab 4, page 28, and the EF number at page 28. Just get that. Is EF number 53. Also, I'd refer to the Attorney General's case at paragraph 47, core bundle, tab 4 at page 40, the EF number for that being, page EF number 38. So there they say at paragraph 40 that the bill is aimed, paragraph 47, page 40. There they say that the bill is aimed at protecting the rights of service users to access certain health services protected by Article 8, and to a lesser degree the rights of those accompanying them and those providing services. And at paragraph 52, the attorney at page EF number 41 also says that they concur with the analysis of the Court of Appeal in Dilguria and accepts that the Article 8 rights of service users are engaged by the acts which are prohibited by Clause 5.2a, and that the clause has a legitimate aim in protecting those rights. So it may be helpful if I start by summarising my position on Article 8 in order to put in context, as the Court of Appeal did in Doguria at paragraph 57, page 567 of tab 6 of the core, the first volume of production of authorities, the interference with rights under Articles 9 through to 11. What I would say is that Article 8 has at its centrality the protection of every individual's right to personal autonomy. And in that respect, I quote again from Doguria at paragraph 57, authorities at tab 6, page 567 of the electronic format. The right to personal autonomy has at its core that everyone has the right to seek counselling and advice from healthcare professionals in order to provide informed consent for medical treatment such as abortion. The information necessary to be able to give informed consent on abortion will include treatment options and material risks of injury, and should be conveyed in a manner that is comprehensible, and a patient should not be bombarded by information. And in that respect, I would refer the court to the authority of Montgomery against Lanarkshire Health Board, which was reported at 2015 Session Cases, Supreme Court, page 63. Montgomery isn't in the bundles that are before the court in electronic format, but I have had the case put before the court, and in particular, I would make reference to paragraphs 82 and 90 of that decision.
Yes, we do have this in our folders for this case as a separate PDF.
Yes, so I needn't then take the court to paragraphs 82 and 90.
I'm sorry, I wasn't meaning to interrupt you. It was just for the benefit of my colleagues.
Oh, thank you. Well, I think it might just help to put in context what I'm saying by looking at paragraph 82 and at paragraph 90, because it is helpful to understand the basis upon which these decisions have been made by service users to these clinics, and the very intense issues that come to fore when we're dealing with the sort of issues that these young women or older women are dealing with in these very difficult circumstances. So looking at paragraph 82 of Montgomery, there the court explained that in the law of negligence, this approach entails a duty on the part of doctors to take reasonable care to ensure that a patient is aware of material risks of injury that are inherent in treatment. This can be understood within the traditional framework of negligence as a duty of care to avoid exposing a person to a risk of injury which she would otherwise have avoided. But it's also the counterpart of the patient's entitlement to decide whether or not to incur that risk. The existence of that entitlement and the fact that its exercise does not depend exclusively on medical considerations are important. They point to a fundamental distinction between, on the one hand, the doctor's role when considering possible investigatory treatment or options, and on the other, her role in discussing with the patient any recommended treatment and possible alternatives, and the risk of injuries which may be involved. And at paragraph 90 on page 86 of the judgment, it also points out that secondly, the doctor's advisory role involves dialogue, the aim of which is to ensure that the patient understands the seriousness of her condition and the anticipated benefits and risks of the proposed treatment and any reasonable alternatives, so that she is then in a position to make an informed decision. This role will only be performed effectively if the information provided is comprehensible. The doctor's duty is not therefore to fulfilled by bombarding the patient with technical information which she cannot reasonably be expected to grasp, let alone by routinely demanding her signature on a consent form. In this context, it's important to remember that abortion is an intensely personal, private, and emotive matter, and falls within the notion of private life under Article 8. Reference again Doguria at paragraph 53, page 566 of the electronic folder. And there are few greater invasions of personal autonomy and bodily integrity than a woman carrying a pregnancy to term against her will. Again, Doguria at paragraph 54, page 566, citing Baroness Hale in the case of INRI Human Rights Commission for Judicial Review, Northern Ireland abortion, at paragraph 6. That's in the authorities at tab 35 and in the electronic folder at page 1435. The provision of effective access to reliable information as to the conditions for the availability of lawful abortion and the relevant procedures to be followed is directly relevant to the exercise of personal autonomy. The case of Doguria at paragraph 55, page, I think I've checked it, it's 55, page 566 to 567, citing P against Poland at paragraph 111. I should point out that P against Poland is also produced by the interveners, the Human Rights Commission, in their bundle at tab 76, and is referred to paragraph 30, page 68 of their written case. The right of personal autonomy protected under Article 8 extends to the right to attend for elective medical procedure, such as abortion, and having come to an informed decision to undergo that procedure. So having decided to present for an elective medical procedure, the patient can reasonably be taken to have taken an informed decision to have that procedure. It would be inappropriate and indeed unlawful for clinicians to present additional conflicting information once the patient has arrived for treatment. And by parity of reasoning, it is legitimate to protect the patient from those who wish to influence and change the treatment decision that's been made. That is especially so in respect of this most personal, private, and emotive of decisions. If such a patient is protected from being bombarded by information by her clinicians, it is legitimate to protect her from being bombarded by others as she arrives at the clinic, whether that be overtly by way of protest, by placards, shouting, and avert conduct, or by those sitting in silent judgment that can be just as effective as bringing to bear psychological influence. And I'll come on to deal with the question of that sort of protest and whether or not we can indeed categorise it as protest in the way in which Ms. McLennan has referred to during his submissions. In my submission, these rights of personal autonomy in this most personal and intimate matter are interfered with by those persons seeking to influence that exercise, both the process of seeking information and advice to arrive at an informed decision and thereafter in proceeding with the decision. The Northern Ireland Assembly was entitled to consider the protection of those personal autonomy rights, a social right, and whether that protection would justify an interference with the rights under Articles 9, 10 and 11. That latter interference should be addressed in the context of itself being an interference with the Article 8 rights of personal autonomy. So in summary, pulling together my observation on the proportionality question in clause 5.2a is not an inherently or necessarily unjustified or unjustifiable interference of rights under Articles 10 to 11. The focus of the Attorney General of Northern Ireland's case being on those rather than Article 9 to protect the Article 8 rights of personal autonomy. So my summary focuses on the woman. Protected persons extend to those accompanying the woman at her invitation and those working in the premises. The interference with the Article 8 rights of those persons, and at least the companion, is of a far lesser degree. That said, the operators of premises will not know the number of patients attending in comparative terms to their companions and employees. Likewise, the protesters will not know, and at least not always know, who is the patient and who is the companion or the employee. The safe access zone is to protect the patient, and that protection includes protecting those who accompany her and who are there to advise and treat her. A friend or relative, a mother or father, a grandparent or sister or brother, as opposed to the pregnant woman, may attend the premises in order to obtain advice for her, for example, leaflets, and they may well fall within the definition of protected person. A restriction on influencing the friend or relative is, I would argue, justified, as it is simply impracticable, if not impossible, to identify in advance who might attend for the purposes of obtaining information. Matters may be different if the premises in question were only there for the provision of advice and information, as opposed to premises where treatment is carried out, as well as the provision of advice and information. The general measure applicable to all three categories of protected persons is justified to protect the personal autonomy of the rights of the pregnant woman. And we know that the pregnant woman can be a child, can be the victim of rape, can be an older woman who is pregnant with her third child, perhaps as a disabled child, and is again carrying a child with fetal abnormalities. There is an enormous range of the vulnerable women who are seeking to access these services, and they are entitled to have their Article 8 rights protected, and the protection afforded to them must be widened to those who accompany such a vulnerable individual in such circumstances as they find themselves. So after that summary of my position on Article 8, can I return to the issues of principle that I referred to in my opening remarks? The first issue of principle is the approach the Supreme Court should take in determining a pre-assent reference. And in my submission, the approach is to ask whether a provision, in this case, clause 5.2a, will in all or almost all cases be incompatible with convention rights. If not, the provision cannot be said to be beyond legislative competence in the abstract. In this respect, I would refer the court to the authority of Christian Institute against the Lord Advocate, which is in Authorities tab 2, paragraph 87, and I'll just get the electronic folder number. At page 434. I'm looking at paragraphs 87 and 88. That particular decision. I think we read with Mr. McLennan 87 and 88. And I'm also wishing to refer to the case of R. Beebe against the Secretary of State for the Home Department, authorities at tab 34 at paragraph 2, pages 1403 to 1404 of the electronic folder. And indeed, these particular references are fully set out in our written case at page 72 of the electronic folder, paragraphs 12 and 13. And so going to the passage at paragraph 2 in Beebe, I think it's important which is at page 1403, to look at what Lady Hale said there, because it's very much reflected in what was said in Christian Institute, which is that the appellants argue that the rule is an unjustifiable interference with the right to respect for private and family life protected by Article 8 of the European Convention for the Protection of Human Rights and Fundamental Freedoms, or that it's unjustifiably discriminatory in securing the enjoyment of that right, contrary to Article 14 of the Convention, or that it is irrational and therefore unlawful on common law principles. They have set themselves a difficult task. It may well be possible to show that the application of the rule in an individual case is incompatible with convention rights. It is much harder to show that the rule itself is inevitably unlawful, whether under the Human Rights Act or at common law. In the attorney's written case at paragraph 22, the Attorney General herself says, the submission for the reasons outlined below explains that the offence as currently set out in the bill could result in a disproportionate interference with convention rights of the potential protesters. So I think that Mr. McGlennan took the court to the case of McLaughlin, but I think the authorities of Christian Institute, which refers to our baby, are very clear, and the position really is beyond doubt in terms of the analysis that's provided there, and supports entirely the first issue of principle that I'm relying on in terms of the approach the Supreme Court should take in determining a free assent reference.
So can I just be clear, what is your submission? If we were to accept that, does that then preclude our examining the matter at all, or what is the relevance of that principle, the task that this court has to undertake? Is it some knockout blow right from the start? Is that what your submission is?
It is, yes, it is, because we're not at we're not in a UNCRC case. We're not in the case that Mr. McGlennan referred to, which was essentially a legislative competence question. This is not that sort of case. This is very different. The task here is whether or not clause 528 is, or almost always will be, incompatible with convention rights. If that's not the high hurdle, if that high hurdle rather is not passed, the answer to the references, yes, it is within competence. And it might help just to look again a little bit at what the UNCRC case was about. It's at tab 36, page 1539 of the authorities. And without looking at that in detail, at the moment, I think I can summarise what happened in that case. The approach that I'm relying on...
Before you go there, could I just, before you go there, say we were against you on the proposition you've just put forward, that that very high threshold is not something that the your opponent has to overcome, but that the correct test is, as he submitted, the McLaughlin test, that is that the bill must inevitably operate incompatibly in a legally significant number of cases.
Yes.
What would you say about if we were to accept that? Do you say you can't, your case falls apart, or do you say in any event that test would satisfy?
So it would satisfy that test because on an analysis of the provision that I'll come on to deal with later, it's a provision that's clear. It was within the it's proportional. It was within the margin of the area of work of the Northern Ireland Assembly, and it's a provision that doesn't have the consequences that are referred to in the McLaughlin case. It's not a provision that will produce cases which will result in an unlawful outcome. It's not a case where there'll be a number of illegal convictions.
So what I think saying is, ultimately, it doesn't matter for you.
Yeah.
Which actual test one is applying, because you would say you win in any event.
Yes. Yeah. I think my fundamental point though is that the McLaughlin case was dealing with something different. The relevant authorities are Christian Institute and BB, but that's why I did spend some time on the Article 8 analysis to place the process of balancing the competing rights in this case in context, which is what the Northern Ireland Assembly did do in bringing about this legislation. So I agree with what you've said, Lord Burrows, that I win on any analysis. So perhaps just dealing with the UNCRC case at this point, my approach doesn't run counter to what the court held in the UNCRC case. The Supreme Court held in that case that it should be possible to determine from the outset whether a provision falls within legislative competence of the Scottish Parliament, and I suppose by extension also the Northern Ireland Assembly, or not. And in that case, the court looked at Section 101 of the Scotland Act and said it wasn't to be used to enable the courts to undertake a rewriting of legislative provisions that were plainly and unambiguously on their face outside legislative competence. Clause 5.2a, and indeed the bill itself, is not plainly and unambiguously out with legislative competence. In the UNCRC case, at page 1557, it was accepted that the duty under the Act to ensure future compatibility with the UNCRC may relate to a reserved matter, and hence was beyond legislative competence. But that could be addressed by a subsequent court, placing a corrective limitation in individual cases to work out if a particular function did in fact relate to a reserved matter. As Lord Reid described it, there was a deliberate excess of legislative competence, which it was argued by the Lord Advocate in that case, could be corrected in individual cases. But my submission doesn't invite postponement of legislative competence in this case. Rather, I say the legislative competence is properly addressed at this time, having regard to the approach applicable for a legislative competence challenge based on convention rights. Would it always, or almost always, be incompatible with convention rights and to the duties of public authorities under Section 6 of the Human Rights Act? The second issue of principle that I'll come on to deal with. So essentially, this reference is different. It raises a different question to that of the UNCRC case, where the impugned provision was clearly relating to a reserved matter, and they attempt to use Section 101 of the Scotland Act to bring that otherwise incompetent provision within legislative competence. As Lord Reid himself noted at page 1559, having discussed the case of DS against Her Majesty's Advocate, the Section 3 Human Rights Act exercise, the court's task was on the interpretation of the legislative text to see if it related or not to a reserved matter. No such task arises in this case. The task here for the court is whether Clause 5.2 is, or almost always is, incompatible with convention rights. So applying then the all or almost all approach to this reference, I would say this: the bill sets up a framework for the establishment of safe access zones and associated penalty provisions prohibiting certain conduct, including Clause 5.2a. The operator of the relevant premises must request the establishment of the safe access zone. As the Attorney General notes in her case in the core bundle at tab 4, page 30, paragraph 16, most operators will be public authorities for the purposes of the Human Rights Act, Section 6, and so they must act compatibly with convention rights in coming to a decision to notify a wish to be protected premises. The Attorney General also further noted at paragraph 22 of her written submission at pages 31 through to 32, Clause 5.2a could result in a disproportionate interference. In other words, it is not an inevitable interference. So in order to act compatibly with the Section 6 Human Rights Act duty, public authorities could only lawfully request a safe access zone with attendant penalties if that was justified in particular circumstances. The public authorities would require to assess the proportionality of any interference with rights under Articles 9, 10 and 11, balanced against the Article 8 personal autonomy rights, in order for the safe access zone to be justified. That being the case, the bill and the clause 5.2a, should and could in principle at least only be operated in a manner which is compatible with convention rights, and any interference with rights under Articles 9, 10 and 11 would require to be justified in order to comply with Section 6 of the Human Rights Act duty incumbent upon authorities, which in most cases will be the relevant operator. To bring this to a close, see it's just after 4 o'clock. In other words, I would say this: it's just not possible to conclude that Clause 5.2a is inevitably unlawful under the Human Rights Act, because it may be required to protect against an unjustified interference with the personal autonomy of women. And so I wonder if this is an appropriate point to stop for today, Lord Reid.
Yes, if that's convenient for you, Lord Advocate, then by all means. I've had no notification that the engineers have managed to sort out the air conditioning. So unless you hear otherwise, we can presume we'll be sitting in the same format tomorrow. We've obviously lost a good deal of time today. We may or may not make up time tomorrow, but in the event that we don't, are people in a position to sit after lunch if we need to complete the hearing then? It looks as if people generally are able to. Good. Right, I'm not encouraging that, but it may prove necessary. Very well. In that case, for no other matters, we'll adjourn for the day and resume at 10:30 tomorrow. Thank you very much.